All right, well, it is 5:01, so we can call the May 1st, 2025 City of Delray Beach Board of Adjustment meeting to order.
Call the roll.
Call the roll.
Jesse Slasser.
Here.
Tiana Morales is absent. John DeLacio.
Here.
Brenda Cullinan is absent. Mark Ronald.
Here.
Michelle Wilson. Here. Richard Kasser.
Here. All right, we have a quorum. All right, so now we will move on to the approval of the agenda. Does staff, are there any changes to the agenda?
No, sir.
Okay. We have a motion to approve.
Motion to approve.
Seconded.
All in favor?
Aye.
Opposed?
All right, motion passes. Okay. Are there any minutes on the agenda? There are no minutes on the agenda, so we can move into swearing in of the public. So if you intend to speak, please stand.
Please raise your right hand. By the authority vested in me, the notary of the state of Florida, do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay, do we have any comments from any of the public members on non-agenda items? Okay, well, we can move on to the presentations.
Since this next one is quasi-judicial,
Okay.
if you want to go ahead and read the
Should she
Oh.
read it into the order first?
Sure, she can enter it.
Yeah.
Okay. Jennifer Buse, planner for the city. This is file number 2025-070. And it's for 612 Southeast 3rd Ave.
Okay, so, as informed, this is a quasi-judicial hearing, so we will read the rules. This hearing shall be conducted in accordance with the City of Delray Beach quasi-judicial rules. The applicant and the city shall be permitted to present their case. The public shall be allowed to speak for 3 minutes each, or a maximum of 6 minutes if the person represents an organization or a group of people who are present but agree not to speak. The commission, board members, staff, and the applicant may be allowed to cross-examine a witness. The city or the applicant will be allowed to offer their rebuttal testimony. The decision to approve or deny an application or appeal may not legally be made upon personal views as to whether a project is a good project or not, nor may a decision be made based on the numbers of citizens who support or oppose a particular project. The law requires that all decisions must be made on the basis of whether the project meets the requirements of law, the comprehensive plan, and the land development regulations. All right, so now that that is done, are there any ex parte communications?
I emailed 3 questions to city staff about the application.
I
emailed a couple of questions as well.
Okay. And I drove by the property as well as looked it up on Google Maps and the property appraiser's map.
Just for the record, before we begin on this, I know some of you have seen this before, but for the purposes of this hearing, it'll be like the first time you guys have ever seen it, so just consider the evidence that's presented to you today.
Right.
Thank you.
All right. If the applicant is ready.
Good evening, Chair and board members. My name is Chuck Halberg, 120 Northwest 4th Avenue, right around the corner here. And I'm also the owner of Stewart and Shelby Home Builders at 1116 Southwest 10th Avenue in Delray Beach. We're a longtime local award-winning custom home builder who also has a passion for affordable housing, so I work with cities and nonprofits providing that. We're here today requesting a variance for 612 Southeast 3rd Avenue for the pool rear setback from 10 feet to 8. The owner, Mr. Bender, purchased the property on January 30th, 2023, and hired an architect to design his new home for his son. The architect obtained the required setbacks from the city along with maximum lot coverage so he could confirm he could design something his client wanted. The home was designed and plans were then sent to my company on June 27, 2023. These plans showed a 12-foot pool and a 10-foot setback, as at the time the client and architect had not been informed and were not aware of the potential city requirement. Understand this is a 50-foot lot of record in an R1A zoning district that requires a 60-foot lot. So the owner had to design the home deeper within the setbacks and for the size home that he wanted and that was allowed by code. Mr. Bender then hired my company to build his home. And in the permitting process, we found out that the city would require a 2-foot right-of-way for future alley widening. This alley runs 4 blocks from Southwest 6th Street south to Southwest 10th Street. Understand that the current alley is pervious concrete and was just built in 2023. To widen the alley would require the city to obtain a 2-foot right-of-way from 52 additional properties to widen it, in which right-of-way can only happen if the property owner tears down and builds a new home or maybe performs a major addition on their existing home. Based on the city requiring the 2-foot right-of-way, the architect updated the site plan to reflect the request for the 2-foot right-of-way and showed the pool at 10 feet to meet the required 10-foot setback. The surveyor plot plan continued to show the pool at 12 foot. Both the architect's site plan and survey plot plan were approved by the city as part of the permit package. Upon receiving the permit package from the city and starting the pool design, we realized the discrepancy in the plans as the builder and that an 8-foot setback would require a variance as the pool is already only 5 feet away from the structure, and that is the standard minimum distance you typically keep a pool away from the structure. I'll tell you that in my 45 years building in South Florida, I've built at least 300 pools on homes, and our typical minimum size for a pool is 12 by 24. It's not to say any aren't smaller, but that's a typical starting point for a 50-foot lot. We are here today to request this variance. And let me clarify, I said that about 5 feet away from the house structure, and that's a structural issue. If you get closer, it's a problem with the foundation and everything. We are here today to request this variance for the rear yard setback from 10 feet to 8 foot, which is only required because the city is taking 2 foot from Mr. Bender's property. And this information under normal design review was not available to the owner or the architect at the time of designing the home. Thank you for my portion here.
Good evening, Chair, board members. Corey O'Gorman, Place Planning. I'm a certified planner. Have been working in the public and private sector planning and community development world for over 40 years. I would like to focus in for a moment on one of the criteria for granting a variance. Under the code, it's item F, which is that granting of the variance will be in harmony with the general purpose and intent of existing regulations and will not be injurious to the neighborhood or otherwise detrimental to the public welfare. The staff report does point out that the intent of the pool setback requirement is not to infringe upon the neighboring properties and to maintain a uniformity in the streetscape within residential neighborhoods. The pool is designed at the 8-foot setback with the 2-foot encroachment that's requested under the variance. Is screened from public view. It would have no impact on the existing neighbors. Certainly, there's no impact on the rear to the alleyway. The pool is at grade. It's not visible, and it wouldn't encroach into any easements. It wouldn't have any impact on any public facilities or private utilities. So granting of the variance of 2 feet would not have any impact on adjacent properties, on-site drainage, utilities on or off-site, or the function of any public services whatsoever. And as such, it would be in harmony with the general purpose and intent of the setback regulations and would not be injurious to any part of the nearby neighborhood. Thank you very much.
For the record, Michael Weiner, Saxon Kaplan, with a business address of 611 Broken Sound Parkway, Boca Raton, Florida. Since I know many of you have heard it, so I will go quickly through it. As well, staff is making a presentation, and they often have more information on the particular details than even we can present. So I'll get you familiar with it but I'm sure you'll hear from the staff more details with respect to this particular lot and project. Let me see if I can go forward here. So this is the Papa view. You can see the lot. That's the location. Some of you said you have been by it. There are setback requirements in the code. It is a 10-foot setback. We are proposing an 8-foot setback. I am sure that they will walk you through that particular code provision of 4.6.15 G1A. This is a detail of what will happen in the back. The variance is granted. The 2-foot dedication is up against the alley. It is going to be, the pool itself is going to be screened by the opaque wall that you heard from Mr. Gorman. Here is that rear alley as it exists, and you heard Mr. Halberg say that there's more than 50 homes from which you would have to have a 2-foot easement in order to get a 20-foot alley. You'll notice there are some utilities there. It is a major proposition, to say the least. You can also see how it is that the pool does not have any impact whatsoever on the neighborhood. Here are your variance findings, and I'll stop here because this is mostly what I'm going to be talking about, but you now have some familiarity with the actual location. So I represent Mr. Garrett Bender. He previously bought the property at 612 Southeast 3rd Avenue in order to build a future home for his son. You heard Mr. Hallberg's testimony with respect to some vital facts that concern this request for a variance. You also heard from Mr. Gorman, a land planner by profession, how it would have no impact on the neighboring area and was consistent with the code. It's been acknowledged for the record that this is the second time that this has been heard by you. And we're certain that the Delray Beach staff will add to this presentation. We do have an opportunity for rebuttal, but we may fill in what the staff has to say. It's unusual that staff, most cities, the staff presents first and then the applicant presents. So I can't be certain that they'll fill in every single box, but I know them and they do an awfully good job of making a presentation. If for one reason or another I think that somehow or another they missed a key fact, then I will in a rebuttal speak to you. My presentation as a land use attorney and having practiced in this area for more than 40 years will be to explain to you why it is that the circumstances surrounding this particular request complies with the 6 requirements under Section 2.4.11 A5 of the Delray Beach Land Development Code. You're already aware of the fact that this lot was a legal lot of record, having been platted in the year 1913. Accordingly, when the property was later zoned to R1A, that happened later, it was grandfathered under the local code. So without a question, nobody's disputing it, a single-family house can be built upon it. Similarly, as the staff report points out, right-of-way dimensions and dedications, whether private or public, can be requested, and when requested will be consistent with table MBL-1. Now, MBL-1, that table, that's not in the city code. That's in the city comprehensive plan. It's sort of dragged into the code by a reference to it in the subdivision sections. It is aspirational. The city wants and desires that sometime in the future that everything comply with table MBL-1. And in this table, it says that alleys should be 20 feet wide. The city comprehensive plan was adopted more than 100 years after this lot was established to be built as a single-family home. The comprehensive plan also says in a policy, actually an objective, MBL 2.5, very near that table, that it shall provide for the acquisition of future public rights-of-way. But as you know, the city's not purchasing this land from Mr. Bender. That has not been offered. There is no condemnation. What is occurring is that the city wants to fulfill their comprehensive plan aspirations by trading a permit for a house, a right that was established 100 years ago, and being able to be on its way to expanding that alley. The government agency is requesting approximately 100 square feet of the private property, and as I've said, for which there will be no compensation. It is this set of circumstances that brings us to the request for a variance, and that's critical. But for the city's aspiration to increase alley widths, no variance would be requested. We wouldn't need it. That is a fact from which a private citizen is not only allowed but should ask for relief. There is nothing self-imposed about this particular instance. We are being asked for, they have not already taken, they would like 5 feet of land. That is what drives us to this podium for this presentation at this time. When those kinds of circumstances happen, actually the United States Supreme Court has things to say about it. There's some very famous cases about it. But the last one was actually decided in 2024. It's Sheets versus City of El Dorado, and for the board attorney, I have copies of my cases here if you would like them. Supreme Court Justice Amy Coney Barrett said, when a private property owner complained about, in this case, traffic impact fees when he applied for a house permit. This was in California. The justice said, the bargain takes on a different character when the government withholds or conditions a building permit for reasons unrelated to the land use interest. The landowner is likely to accede to the government's demand no matter how unreasonable, so long as she values the building permit more. Because such conditions lack a sufficient connection to a legitimate land use interest, the amount could be an out-and-out plan for extortion. Not my words, just what the justice said. The justice refers to some other landmark decisions that you probably have heard about. Nolan versus California Coastal Commission and Dolan versus the City of Taggart. Everybody knows them as Nolan and Dolan, and they always misspell them because there's 2 L's in one and 1 L in the other. But those cases, along with Sheets, form the foundation by which certain regulatory takings can be made and certain ones can't be made. Both cases all 3 cases deal with extractions when a government entity imposes conditions on land use permits. These cases establish that any extraction must satisfy specific legal criteria to ensure that the government demands are not unfairly burdensome, what Justice Barrett mentioned. Here, my client is asking for the enlargement of a 2-foot pool, by 2 feet of its pool. There will be nothing above ground level. There's no added habitable space. A larger pool will have no impact on the surrounding area. That's what we're asking for. Here, the city is taking 2 feet to comply with the general condition on roadway widths, something for the general public. We know there's 52 homes involved. We know the people who go down there. Our entryway is not on the alley. In fact, we're going to be cut off from the alley. So the alley is of no significance to this particular house. It's for a general use to improve things generally within the city. So we are a lot like Sheets. Understanding this particular set of circumstances, we must now take a look at how these kinds of issues are often handled in the state of Florida. In order to give leeway for such requests, the granting of a variance became a time-honored method. The aspirations, we're not the first people this has ever happened to. The aspirations of a government agency to obtain a future goal could be achieved for a public good, and at the same time, a private owner could receive an expected use of his property. Some of the first mentions of the variance tool go back about 75 years in Florida. There's a Florida Supreme Court case called Joseph versus Autry. It was actually decided in 1957. It actually refers back to another case decided in 1948, Wheeler versus Lawrence. And what that earlier case said is boards of adjustment or zoning boards of appeals are customarily provided for by ordinances to examine situations where strict adherence to the letter of the ordinance would produce a unique or special hardship on the particular property owner. Historically, these appeal boards may grant relief in connection with such problems as setback lines. That's what we're asking. Areas and height restrictions, side lot lines, and the like, when not contrary to the public interest. You've already heard from Mr. Gorman. There is nothing contrary to the public interest here. So granting a variance is not a dirty word. It isn't the avoidance of the application of any law. It is fundamental so that you can avoid the circumstances that Justice Barrett mentioned, so that you don't take an extraction. A variance is not a bonus. It's not underhanded. It's just a long-honored technique to clear a situation so that a public good can be benefited, and a private right is not trampled. Having established this understanding, we can now look at the 6 criteria, and they're listed up there. First, special conditions and circumstances do exist which are particular to the land, structure, or building involved and which are not generally applicable to other land structures or buildings subject to the same zoning. We actually have 2 circumstances here. The first is that we're a grandfathered lot, and the second one is the policy of the city's comprehensive plan that they seek to obtain additional private property from us for the general public good of improving that right-of-way. That's not for every R1A zoning lot. So it's
Mr.
not
Weiner,
generally be applicable.
Just be mindful that you have about 3 more minutes left.
Considering the situation and the explanation of it, use some of my time.
It's a decision of
I
the
am
board.
almost
so-
done with the board. Could I have a few more moments? Thank you. I will do this as quickly as I can. Second, after all, there are 6. I wish there were 4, then I could probably do it in 2 or 3 minutes. I'll go quickly. Second, the literal interpretation of the regulations would deprive the applicant of rights commonly enjoyed by other properties subject to the same zoning. Other R1A lots commonly enjoy improving their lot with the full surface area of their land that they own. The application of an aspirational item by the city would deprive my client of that common right. Third, the special conditions and circumstances have not resulted from the actions of the applicant. The special conditions or circumstances are not that my client seeks to build a standard size pool. You heard from Mr. Hallberg, this is just a standard size pool. The special conditions and circumstances are that the city would like 100 square feet in exchange for a permit. That's the special condition. I point this out to you so that you are looking at the problem not as if the land has already been taken. They're requesting it that it be taken. So the special condition that exists is that they would now like to step up and take the land in exchange for a permit. We would not be here if that were not the case. That's the special condition. It has nothing to do with building a standard size pool. Fourth, granting the variance will not confer on the applicant any special privilege that is denied to other lands. I'll abbreviate some of these things so I can go more quickly. So generally, of course, the city can carry out the policies set forth in their comprehensive plan. It can do so by bringing a condemnation action, didn't do that here, or by making a request for the land without payment, as it has done here, in exchange for a permit. If in response an owner asks for a variance, you will consider it as you are considering this variance. So, in fact, you can grant this, and you won't be conferring on us any special privilege that if somebody wasn't also in this circumstances, you do the same, you would listen, right? So we meet the 4th standard. 5th, the reasons set forth justify the granting of the variance, and the variance is the minimum variance that will make possible the reasonable use of the land. Certainly, we have already established the reasons to justify this. The city wants 100 square feet of land. With respect to the minimum variance, the city is asking for 100 square feet of land. The owner just wants to enlarge his swimming pool by 60 square feet. That's all he wants to do. Mr. Halberg has already testified that 12 foot is the standard size pool. So the larger pool just makes a reasonable use of the land, and that's all the ordinance requires. So we meet this standard. Sixth, the granting of the variance will be in harmony with the general purpose and intent of the existing regulations. You've already heard from Mr. Gorman on that. The variance is in harmony with the general regulations. In fact, it's interesting because in the same comprehensive plan, there's a housing policy 4.2.9 that says new development should include recreational amenities that promote and encourage healthy living. So we know we're consistent with that. Certainly, a below-ground pool hidden by an opaque wall from an alley, which is where it's located, will not be injurious to the neighborhood. Mr. Bender's situation meet all the conditions of our local ordinance point by point. Remember, you establish no precedents here. You get to hear other people who have other difficulties with requests that the city may make that impacts their plans. So you're not giving away anything. You haven't set any precedent. Everybody gets to make their own arguments. For this case, based on these facts, there's substantial competent evidence introduced, and there's substantial legal precedent upon which you can find that a grant of a variance meets all the requests. I thank you for your time. I'm sorry that it had to be so straight to the point, but I'm hoping that you'll realize that this is the way to deal with situations such as we have before us.
I just want to remind everybody, this is a new hearing, so everything that you hear today needs to be taken into consideration, not last month. Okay, so this is agenda item 7A. It is for 612 Southeast 3rd Ave. This is for a consideration of a variance to the land development regulation for swimming pools, whirlpools, and spas. The yard encroachment to reduce the rear setback to 8 feet. 10 feet is the required setback. Just very quickly, this is in the R1A zoning district, so it is a single-family residential neighborhood. This is just an overview of the block. You can see with the alleyway and the 2 streets, the 4 streets actually enclosing everything together. So as stated before, the rear setback for a swimming pool is 10 feet. And the request is for the a relief of 2 feet so that it would be set back at 8 feet. The proposed pool size is 12 by 30, which is 360 square feet. A little bit of history on the permit is in 2023, a permit was approved for the construction of a new 2-story single-family home. And on December 12th, engineering did make a comment that a 2-foot dedication for the alleyway was required. This was prior to CO. And this comment was made at the prerequisite of engineering and planning and zoning making their comments. It's a little hard to have the permit to expect the 2-foot alley to be at the CO, because if that is the case, then all of your plans have to change if the variance isn't met. So on January 15th, there was a version 2 of a site plan that was submitted with the 2-foot dedication, and it was showing a reduction in the pool by 2 feet. So the site plan that was submitted and approved ultimately was a 10 by 30 pool, which is at 300 square feet. And it is showing that it does meet the 10-foot setback.
Could you just give the years with those dates? Because I'm not sure I'm tracking properly what you're saying.
The permit process started in 2023, in December of 2023. And the permit went out on, it looks like January 3rd, 2025.
2024.
No. It was just approved this year. So the lot size for R1A zoning district is 7,500 square feet. The lot depth is 60 feet, and the lot width for R1A zoning district is 100 feet. You have a front setback of 25 feet, a side interior setback of 7.5 feet, and a rear setback of 10. While the lot size is not, it's an existing nonconformity, it should be pointed out that even though it does not meet, the frontage does not meet 60 feet, it exceeds the 100 feet that is required at 130 feet. This is just to point out that this is a lot of record, and the reason why it can be built upon is because it is still the same configuration it was platted in back in the early 1900s. And that brings us to the findings as well. I do want to point out that the comprehensive plan is not 100 years old. The comprehensive plan was revamped and published in February of 2020. And also the dedications for either the front, the alley, for any kind of street classification is done citywide. It's not just one neighborhood, it is done citywide. And some of the, whether it's arterial, collector, or a local street, it could be even a larger dedication that's required. And that concludes.
Okay, thank you. Before we get into rebuttals, are there any public comments to be made? And just confirm, you were sworn in.
Yes,
Okay.
of course. George Long, 46 North Swinton Avenue. I just came here because I was curious. I had no idea I was going to run into Chuck Halliburton and see Michael Weiner, who I know somewhat. And I did drive by and take a look at that. And I am very interested in alleys. I won't get into that. But all I can see here is reasons to pass this, just from the, I'd say the uninitiated public point of view. This all looks good. What the hell? It's behind a fence. You won't see it. It's they've taken the 2-foot extraction, which they for the alley. I don't see any problem with this. It just looks right all over. That's all I have to say.
All right, thank you. Are there any rebuttals or cross-examination from the staff or the applicant?
I have a rebuttal of sorts. So, yes, if there was some confusion in my presentation, we full well know the comprehensive plan is 2020. I just wanted to make mention of the fact that the lot's been useful as a single-family house for 100 years. But more importantly, this is not about the fact that there is a request for a 2-foot additional area for a pool. This is about whether or not 2 feet should be taken by the city for free. That is the special circumstance. And yes, the city does, and that's the whole point. The staff actually made the point for me. It is a citywide aspiration to have wider alleys and streets and larger roads. Now, think to yourself, does one lot owner who had a right to build a single-family house, who had a right to build out all the property that he owned, the complete surface area, does he need to bear this particular public situation on his property alone,
Mr.
and
Weiner,
therefore,
I'm going to go ahead and stop you. I think that this is absolutely about the variance. Whether you want to use the right-of-way as a justification, that's certainly up to you guys. But the only thing that is before you today is the variance. The right-of-way is dealt with at the engineer level. So I just want to make that clear to the board.
I wouldn't have an argument with you that the variance is before you. The question is whether or not the satisfaction of the special condition. That's the issue.
Okay, and I agree with you there. I think what you
Thank you.
had said was that this was whether the city could take that right of way or not, and I just want to make it clear to the board that that is not something that they're deciding today. They're deciding on the variance.
And I appreciate that, because if I haven't made it clear to you, it is about the 6 conditions. No deed will be required as a result of what you're doing tonight. The only thing that will happen is that obviously a deed will be a condition of the grant of the building permit. That's when they'll get the deed. Obviously, if you don't grant the variance, then there's other situations, because I don't think that we're in a position to say that that the landowner should be the first person to give up 2 feet of his property under these circumstances. And I don't mean, we're not putting it to you or anything else. We're just trying to meet 6 requirements in an ordinance that I think the case law and other items show we have met by substantial competent evidence and by the precedent of cases. Thank you.
Thank you. Staff, is there any rebuttal?
I do. When you are up there for discussion, again, just really look at the 6 findings. Realize this is a new construction, and that when we're talking about the pool at 12 by 24, which is a standard, that's 288 square feet, or 288 feet, and a 10 by 30 pool is larger than that.
Okay, all right. We can go to any other members of the applicant's party wish to speak? Okay, well, we can go to board discussion, so we'll start from this end and work our way down.
I just want a little bit of clarification if I can. I'm under the understanding from what I've heard that at least since 2020, this requirement for for the increased right-of-ways throughout the city has been in place.
Correct.
Thank you. I'm personally aware, and I imagine you are as well, that many people, this is not the first time this has happened. This is going on all over the city. And at least in the neighborhood that I live in, quite a number of areas have given up. They're 2 feet on one side, a few years later, 2 feet on the other side. I don't know of any single street where everybody's given up, but there's certainly the passage on those lots have improved, and that's what the city's interested in. I realize, however, that's not the issue here. The issue is the pool. But personally, you know, as a resident of the city, you get a benefit when some of this stuff happens. I'm a resident of the city. I give up certain things in order to get certain benefits. So personally, I don't quite have the same perspective on any give and take here. To my mind, this is an issue of the LDR. And do we want to let pools be closer to the property line? And there are certain instances where I could say yes, you know, where there really is a hardship. But in this instance, given the fact that certainly they should have been aware by 2023, when the land was purchased, that this requirement existed, because most of the places, again, I'd say since 2023, which isn't very far back, I bet you there's 12 or 13 lots just within Palm Trail, which is a pretty small neighborhood, that have given up their, most of them are in alleyways, anything on 7th or 8th. So I would make the statement that I'm kind of surprised that such highly respected and informed people at the time they purchased the land were not aware that this requirement existed to give up to 2 feet. So I don't understand why they didn't plan ahead if they wanted a bigger pool to give it up somewhere else. I'm very concerned on just the subject that was made, that was the rationale for for approving this, granting of a special privilege. To my mind, there's a lot of people that don't like pools too close. And if we granted a back lot against an alleyway, maybe that does make some sense, because it's certainly not moving a pool closer to your neighbor, which I would think would be a real problem. You know, people in pools aren't particularly noisy, but kids in pools tend to be, and you can't blame them. However, sometimes things fly out of pools, balls and whatever, and could go into an alleyway. Some of the statements that are made for the rationale are just a little hard to understand. None of the existing developed properties in the block in the same zoning district are subject to these requirements. Those exist, as I understand it, those existing properties, if they were redeveloped, would be subject to this same requirement. Am I incorrect or correct?
No, that's correct.
So I would say all of the existing developed properties on this block, and by the way, all other blocks that are on alleyways, are subject to this requirement, and have been since 2020.
I think it's subject to development, obviously, but when they come in for
Right, if they,
development that meets the
right.
requirements,
Only
then they would
if
be
you're gonna tear it down
subject to the
and
right of way.
rebuild it.
Dedication, correct.
That's all?
Okay. All right, well, I'll go last, but
Yeah, I'll cover some of the questions I asked staff so that way the applicant can hear as well. So I did ask staff to share the permit application that was referenced in the report that for the building permit, which the final drawing was provided. But I think that the question I'd maybe add on to it, because the applicant referenced it, is that was there a draft submission for the building permit that originally requested a 12 by 30 pool? Because what I'm trying to get at is whether, when I think about whether this was the action of the applicant, if the applicant always contemplated the 10-foot full pool and then subsequently is here asking for the extra 2 feet, or was it originally asked for 12 feet, moved down to 10, and now it's in line with their original request?
So I just want to make it clear too, a pool permit is a separate permit under Florida Building Code, but it is not uncommon to see it on a site plan for the mere reason that you want to make sure everything is aligning up as far as setbacks and whatnot. So when this was first submitted, it was submitted with a 10 by 30 pool.
Okay, but was there a draft application to the city that showed a 12 by 30 pool?
I don't think so. I believe I may have seen it on a survey, but I did not see it on the site plan.
Okay. That was my first question. The second one was when the staff report talks about the intent of this pool setback requirement is to not fringe upon the neighboring properties. I guess I would ask, is there language in the LDR that speaks to what the intent is specific to this regulation, or is that just a general statement?
It's just a general statement. The setbacks are, they're made so that you're not right next to your neighbor. So it is to not fringe upon the neighboring sides.
Okay, and then the final question was can an applicant seek a rear setback variance during the building construction permit process, even though the property feature necessitating the variance is itself not expressly authorized by the building construction permit?
Yes, I can.
Okay, thank you. So those were my original questions. I guess what I struggle with now is getting back to maybe I'll put this question to the applicant as to my first one, about any evidence the applicant can present about the original request for a 12 by 30 pool.
Again, Chuck Halbert, 120 Northwest 4th Avenue. So to I guess back up, Mr. Bender bought the lot, he hired the architect, he looked at the LDRs. This isn't a subdivision that we're building, this is a neighborhood that's existing. And the LDRs, to my knowledge, don't say anything about a 2-foot right-of-way for the alley. It comes up typically in engineering comments. Having built in the area for a long time, when I got the plans, I started questioning it. So the original plan did have a 12-foot by 30-foot pool. When we submitted for permit, I knew they were going to take the alley because I checked into it, because I don't like permit problems, having built here for all the years I've been here. And I realized that was an issue. And we knew we were going to have to come for the variance.
Okay,
Okay.
thank you.
Thanks.
Yeah, I mean, I guess just building on the conversation here, I think I struggle with the setback that's being asked for is within the 130-foot depth of the property, which is 30 feet beyond the 100-foot requirement. And even if there were, I guess maybe a question for the city, because the table I'm looking back from the LDRs, that rear setbacks, there's not a residential rear setback that's less than 10 feet for any of the residential zoning.
There is not.
So even though the property is smaller than the R1A minimum, it's not as if.
Okay. I just have a few, and they should go pretty quickly. So just to confirm, pools are a separate permit,
Correct.
and has the right-of-way dedication in the alleyway, the 2-foot, has that taken place?
Yes.
Okay. And now for the applicant, and this is just for a clarification.
I'm sorry.
No,
Yes.
no worries. This is just a clarification that if the 2-foot right-of-way dedication was not required, that there would be no need for a variance, that this pool would meet all applicable codes and setbacks and requirements.
Correct.
Okay. And now, from a logistic perspective as well, and again, bringing up some of the conversation that we had previously this evening, the pool will be screened in the back by a solid wall.
Correct.
Will there be landscaping on the interior side of the lot?
The shaking of heads for the record indicate yes.
And now, will that landscaping, and how tall is the wall?
6 foot.
6 foot.
6
And
foot tall.
will there be landscaping that goes above the height of the wall?
If it needs to be planted that high, it can, but normally it takes about a year to get up that high, something like that.
Okay, so clusia or podocarpus or, okay.
I'm sure that's what it is. I don't remember exactly.
Got it, okay.
Typically it's Clusia.
Okay, and there will be no access
Come
points.
to the microphone if you're going to testify, all right? Quick.
No.
And there will be no access points from the
access.
alley into the yard.
That's my,
Yes.
yeah, that's correct.
Okay, solid wall.
I just have a lot of projects. I'm trying to remember
Yeah.
that wall.
No, I got it. Okay. All right. Well, that does it for my questions. Does anyone else have any other questions to ask? Any conversation between us?
I guess one follow-up question, I guess both for staff and the applicant, because we talked both in the presentation and in the applicant statement about an unnecessary dedication. Is there any, what does the word unnecessary, what was the intention to convey in that language?
So the situation is this, that the request for the 3 feet is when everyone is using the word required, all right? There isn't a requirement. You haven't, if you've already taken the land, then you've already paid for it. No one on the street has had their land taken, okay? So when it is necessary, so for example, if we wanted to put up an apartment project for 8 units.
Yeah, I think the land's taken. I think my question specifically, the upgrade to the alleyway is unnecessary. And specifically as it relates to the alleyway dedication.
If I may,
Go ahead.
I think you may be referring to some of the language that's in the justification statement.
Yes.
And I referred to the dedication as being unnecessary because the alleyway is already improved. It's already paved. It's already being used. There's no need for it today. So it's unnecessary. If the alley would be improved, as Mr. Halberg pointed out, within a 20-foot right-of-way, that's going to be 100 years from now when the alley has been widened through individual dedications of those 56 property owners.
Paves them because it makes the alleyway a little bit wider, in those areas so cars can pass or kids can pass or bikes can pass, because 16 feet's pretty narrow. So even if it gets one side, it typically takes the one side and does something with it. And there was just a recent project within the city where they cleared a lot of stumps out and other things that were in the way to where they actually owned the land, but it wasn't really passable. So they've been working on making the alleyway passable in little chunks.
Yeah, I guess that'd be my question to staff. Presumably, if the city wanted to take action prior to all the land being donated or exchanged, could they condemn or pursue eminent domain on those 2 feet for the other houses?
That would be at the discretion of the city engineer and Public Works. I can't really.
I think all of this kind of depends on the circumstances, and they're not really the circumstances we have in front of us right now. Could they? It depends if there's a specific, substantial need for it at that moment. And I also think, could they also make improvements as they go? They certainly could, because they would have the dedication. Do they always? No, sometimes it's not till there's a large chunk of project to do it on, but that's available to the city. And just as a comment on also the it being aspirational to take the right-of-way dedication, we have a form-based code, so when the land development regulations refer to another section of a form, a document, a statute, things like that, that now redefines what the land development regulation is saying. So that is the land development regulation, and just because it's not written in that land development regulation specifically doesn't make it aspirational to it is defined. So
Thank you.
did that answer your question?
Yeah, I think I understand it.
I just have one other question, and I'd like for both staff and the applicant just to confirm again, looking at the plan dated 1/9/24 from Place Planning, the 10-foot side setbacks, those are conforming.
They're 7.5, and yes, there was no other relief that was requested or needed.
Okay. And so again, for the applicant, it's 10 feet from side property line to the pool edge.
Yeah.
On either side.
Right, the home was designed per the setbacks, all the way, pool and everything.
Gotcha. Okay.
So no variance was required for the construction permit.
No, and I was a little bit confused when you said side. I thought you meant side interior. It is 10 feet on the side interiors for the pool as well.
Okay. But I mean, that is something else to confirm, that the house the structure itself is conforming on all setbacks.
Yes.
Okay. Correct.
Okay.
Correct.
Right. Are there any other board comments?
Yeah, I mean, I think just generally, I mean, I think there is certainly a better understanding today about the applicant's original intent, that they sought the 12-foot pole on the original permit. So I think that gives some credence to that this was not the fault of the applicant if that was part of the original housing plan. I had concern originally going into this meeting that the applicant had 130 feet to work with. They submitted something that worked within those 130 feet, and now they're back here later asking for those 2 feet. But if we're taking the applicant's word, I think there is credence that this wasn't necessarily the fault or the action of the applicant. Yeah, I'll just add that.
Any other comments?
Could we make one more point of order?
Sure.
The client knows by experience that it takes 5 votes, affirmative votes. Well, I see that there are 5 people here, and we've all listened to the comments. If you would like to postpone for 30 days when we can have, and we should have 7, so that we have an opportunity to talk to all 7 and get to 5 out of 7, we'd appreciate that. From the comments, we are of the opinion that getting all of you tonight will be difficult. So I hope you see that that's only requesting the kind of thing that is fairness under the circumstances. This is important to the client, it's important to the city, and we hope you take that under consideration as you deliberate. Thank you.
So you're requesting to table the vote and then come back at the next meeting and vote then?
I understand that a 6th person, and I don't know if that 6th person is actually here tonight. Is that you, Mrs. Wilson?
I am a member of the board, yes.
Okay. I do know that. I just didn't know.
There's 5 members here tonight.
Yes. There were only 6 members to your board. From what I understand, a 7th member has been appointed and all positions are now filled.
Yes.
We only have 5 of those 7 here. Unfortunately, our code says that it takes a supermajority to grant a variance. We would need all of you to vote in favor of it. We would be more than willing to just, because this is, and I know it's a previous hearing and may not count, but we would certainly be better off if all 7 people were here than 5. So we respectfully request that seems like fairness to all involved to have a meeting with all 7. So we would postpone, yes, until then.
So
Can't the applicant withdraw their request in the middle of a hearing or not?
I think typically we would not recommend that you make this decision based on, the amount of people that are here today. We do have a full board. It seems like, they're subject to the board that's before them. That would be my comments. I mean, ultimately, I think the board can make a decision, but I would not recommend allowing that type of decision to be made based on, it's kind of like forum shopping almost, to like decide now to make that decision to postpone, but I would ultimately leave it up to the board.
Well, so it poses a question, and council, please jump in if I overstate something. But to Mr. Weiner, what is, if we do move forward with a postponement of the vote, is there going to be outreach efforts on your part or the applicant's part to meet with or discuss and try to go through things individually with the board members to address and potentially assuage any concerns in the delay between now and the next meeting?
So ex parte communications are always a difficult situation in that we never want the board members to feel like we're merely lobbyists. However, this would be special circumstances. We would certainly ask them to listen to this meeting and for them to form an opinion by being able to look at the meeting itself. Certainly, we try to do the best job we can for our clients. We zealously advocate their position. But we also respect the boards, and we try not to be seen as lobbyists. We aren't. We're here making propositions. So that would be, in this day and age with these kinds of tools, I think they could listen to the hearing that we've just had and reach a conclusion.
Give me a moment. I'm just going to go through our local rules and just see if there's anything related to this specifically. If I can do that for a minute before
Yeah.
you guys make a.
Of course.
Thank you.
Mr. Chair, can I just make a comment on Mr. Schlesser's comment about pools? Just think about this for a second. 10 people in the block go and put a pool in at the 10-foot setback. 10, 20 years from now, whenever the city decides they're gonna widen an alley, and in all my years in Delray, they've never done bits of an alley at a time. I've never seen that. It makes no sense as a guy who's probably built 100 miles of road in my career and subdivisions and stuff, that you would do that. You build a whole, it could be one block, but you wouldn't like go 20 feet for 50 feet of a property. All of a sudden you'd have 10 houses having built pools, they'd now be non-conforming at 8 feet. I just want to make that was a good question there, because they can permit pools separately. And things happen non-conforming at times, as you guys have seen as a board before. And that's just something, I thought that was important to mention that. Thank you.
Sorry, just one more moment.
So I guess just while we're waiting, what his request is an item the board would have to make a motion on.
To postpone it, yes.
Okay.
And that would have to be a unanimous or 3 of 5.
You vote for
Actually,
continue.
it would have to be a majority because it's not for the variance specifically. So, as far as I'm not seeing anything in the local rules specifically that decide this. If you guys do make the motion, I would suggest that this, like the whole presentation, I would say that the whole presentations have to be made the next time too, so that the board gets the same view of the application and gets to make that decision. So.
I thought a vote to continue usually comes with a specific request that's a continuation of the hearing of the matter, not necessarily a rehearing of the matter. Right.
Right, but then they have to give a presentation. So it just wouldn't be an instruction. I wouldn't say to the board members that aren't here that they have to go back and watch the prior meeting. I would just say, like whatever they want to present needs to be presented to the new board members as well. So.
Okay, well, do we have would it be a motion to continue?
Yeah, I guess a motion to continue would be the best way to say it.
Okay. Do we have a motion to continue until the next meeting?
I'll make the motion to continue to the next meeting.
Do we have a second? All right. No second. Motion does not pass.
Then do you guys want me to go ahead and read?
Yes.
Okay. All right. This is file number 2025-070. The date is May 1st, 2025. Agent Michael Weiner, address 612 Southeast 3rd Avenue. The request is a consideration of a variance request to land development regulations, section 4.3.4K, development standards matrix, residential zoning districts to reduce the rear setback to 8 feet whereas a minimum of 10 feet is required associated with the construction of a new swimming pool pursuant to Land Development Regulations, Section 2.4.11A5. Following consideration of all the evidence and testimony, the Board of Adjustment for the City of Delray Beach finds as follows. 1, that special conditions and circumstances exist which are peculiar to the land, structure, or building involved and which are not generally applicable to other lands, structures, or buildings subject to the same zoning.
Jesse Slasser?
Yes.
Tina Morales is absent. John DeLacio?
Yes.
Brenda Cullinan is absent. Mark Ronald?
No?
Michelle Wilson?
Yes.
Richard Kasser?
Yes.
That literal interpretation of the regulations would deprive the applicant of the rights commonly enjoyed by other properties subject to the same zoning.
Jesse Slasser?
Yes.
Tiana Morales is absent. John DeLacio?
Yes.
Brenda Cullinan is absent. Mark Ronald?
No?
Michelle Wilson?
Yes.
Richard Kasser?
Yes.
That the special conditions and circumstances have not resulted from actions of the applicant.
Jesse Slasser?
Yes.
Tiana Morales absent. John DeLacio?
Yes.
Brenda Cullinan absent. Mark Ronald?
No?
Michelle Wilson?
Yes.
Richard Kasser?
Yes.
That granting the variance will not confer onto the applicant any special privilege that is denied to other land, structures, and buildings under the same zoning.
Jesse Slasser?
Yes.
Tiana Morales absent. John DeLacio?
Yes.
Brenda Cullinan absent. Mark Ronald?
No?
Michelle Wilson?
Yes.
Richard Kasser?
Yes.
That the reasons established in the variance petition justify the granting of the variance, and that the variance is the minimum variance that will make possible the reasonable use of the land, building, or structure.
Jesse Slasser?
Yes.
Tiana Morales absent. John DeLacio?
Yes.
Brenda Cullinan absent. Mark Ronald?
No?
Michelle Wilson?
Yes.
Richard Kasser?
Yes.
That the granting of the variance will be in harmony with the general purpose and intent of existing regulations, will not be injurious to the neighborhood or otherwise detrimental to the public welfare.
Jesse Slasser?
Yes.
Tiana Morales absent. John DeLacio?
Yes.
Brenda Cullinan absent. Mark Ronald?
Yes?
Michelle Wilson?
Yes.
Richard Kasser?
Yes.
Okay, so since there was, I believe it's 5 out of 6 no's, out of the six conditions, that actually requires that there be a motion to deny the variance request, because if all the findings aren't met, then you can't have a motion approving it. So if somebody could make that motion to deny, if you read it at the end, it'll say, the part says pursuant to LDR section 2.17F, all decisions of the Board of Adjustment are final based on the entire record before it, the Board of Adjustment, and then you would have to say denies the variance solely for the purposes as presented at the meeting. Does anybody want to make that motion?
I'll make such a motion.
Is there a
I'm
second?
not sure that the approval, I'm sorry. Do I have to read everything on the page there?
And you can, yeah, if you read B, because you have to move denial of the variance.
Well, I move denial of the variance request for 612 Southeast 3rd Avenue from LDR section 4.6.15 G1 to reduce the rear setback to 8 feet, whereas a minimum of 10 feet is required associated with the construction of a new swimming pool, by finding that the request is not consistent with the findings set forth in the LDR section 241, 2411A, 5, A through F, I think.
Seconded.
And so at this point, the answer would be yes to move the denial, and since there's not a supermajority of the full board with the yeses, that it would have to be a denial from everyone, so your answer would be yes. could call the roll, Diane.
Jesse Slusser.
Yes.
Deanna Morales is absent. John DeLacio.
Yes.
Brenda Cullinan absent. Mark Ronald.
Yes.
Michelle Wilson.
Yes.
Richard Kasser.
Yes.
Okay, so the motion has been denied. The Board of Adjustment has applied the comprehensive plan and LDR requirements in existence at the time the original variance was submitted. The Board of Adjustments finds that there is not ample and not competent substantial evidence to support its findings in the record submitted, and denies the variance before it. Okay.
Okay. Thank you to all who spoke. We can now move on to reports and comments. Are there any staff comments?
As you all can see, there is an updated copy of the meeting agenda on your section of the dais. And I would also like to introduce our new board secretary. Her name is Brittany. She's sitting right here. She will be replacing Diane as our board secretary, and our next meeting is slated for June 5th, 2025. As always, I will provide correspondence to you all within 7 business days of the hearing date.
Okay, thank you very much. Board Attorney, any comments from you?
No comments from me, but, thank you guys for your time again on everything, and we appreciate everything that you guys do.
Okay. And now, are there any board members that would like to make a comment?
Nope.
Nope. Okay. All right. Well,
Actually, one last are we still doing a staff report on variances versus was it?
It is still in the
Waivers.
works. It's our assistant director has been working with us on it, and our absences have not been very timely of each other.
Yeah.
But we are hoping to present that to you all very soon.
Wonderful. Thank you. Nothing further.
any other comments from any board members?
It would be great, but probably not practical, if we could hear from the city commission on their view of this board and the LDR. Any further guidance would be helpful. I unfortunately have my views of how they think, but they may or may not be correct.
I mean, I think you guys have been put on this board by the city commission, and they decided to trust you with your decisions as far as it goes. And if they have a deferring opinion of how things are happening, that they can direct staff to make adjustments to the land development regulations, and then those would be the new land development regulations that are coming before you. I think as staff sees things come up again and again, they will start noting that, and they note it to the city commission specifically to say, we've had these right-of-way dedications and then variances come up a bunch. Is this something that you guys want staff to look at to make sure that we're consistent with like what you want to be happening in the city? So it is something that's always happening. So I just, I don't know that it's something, I don't know that it's something that you need to get direction specifically from them, but direction will be given to staff if they have a difference of opinion on how things should be going relative to these items. That's helpful, because it really does come up a decent amount on the dais during commission meetings, like when they start seeing certain things that are going to,
Well, let me narrow that
boards.
up considerably. And maybe we ought to just try to get a clearer understanding of their view, even though we weren't specifically dealing with the 2 feet dedication, because that's happening. But their view on how important these alleyways are and what they're trying to accomplish and the ramifications. Do they feel that we owe something to the landowners as was pleaded here, or do we not? I mean, do the city,
Yeah.
you know, do we, as we, this short period of time, effectively represent the city in trying to make a decision for the city?
Right, and
Because I think obviously the views across here are different, and my colleagues here do not share my views. And I think we might get somewhat closer together if we heard from those that are a lot higher up and spending full time managing this place.
I think as far as the process for something like that, you know, if you guys felt like certain areas of the land development regulations needed to be looked at, like you were recommending that the city commission look at them or something to that effect, like you think that there may be more details that need to be provided in the ordinance, you could make a motion to do a memo or something of that nature so that it goes up to city commission, and then if they want staff to look into it, they would make that decision. But like as far as keeping with the chain of command, the city commission then would tell the city manager, who would then tell them, so that, you know, you're advising the commission, and then the commission makes those decisions to the city manager and goes down to them. So that's up to you guys. If you want to think about it, you know, you can certainly think about it, and if you have an idea to, you know, write a memo to the city commission, you're always, you know, welcome to make that
I
motion.
have one other comment that I can't resist making. There seems to be a very high tolerance amongst here, legal, and the staff, all of us, for statements made by the witnesses that are not well supported in fact.
I think as far as
And/or just not relevant, like these law cases were clearly not relevant to this particular issue.
I think that
What the Supreme Court said or might not have said out of context.
when it comes to this, with the due process rights, we try to give them a decent amount of leeway in bringing things in if you can find some sort of relevance to it. You know, if we find, and there was a point where I did stop certain things, you know, if we find that it's going past that, we will step in, but we do try to err on the side of allowing things in so that they get their full, you know, chance at their application, so. But you can certainly make comments on it if, you know, if you think differently while you're up here. That's of course up to you to you know, say that. You're welcome to say that during the thing, you know, like, I don't think that that's relevant. I don't think you should consider it, and, you know, the board can take that into consideration as well.
There is a time limit for applicants' presentation collectively?
Yes.
What is that limit?
15 minutes and 15 minutes for both sides, so.
So collective among any applicant representatives is 15 minutes.
Correct. And it's up to the board, though, if you want to give them a little bit more time, you know, but it is 15 minutes, so. And
I'm all
that's
for
in our
giving
local
them more
rules.
time. It's the relevance that causes me some pain.
Well, one of the things that you just said was that your colleagues up here seem to give witnesses and applicants leeway in what they present and things that maybe aren't rooted in relevant facts.
No, I think all of us. I did not exclude myself.
Okay, well then, but
No, I think we've given quite a bit of leeway.
and I think that this
may
was
be appropriate.
and this was probably the first presentation that I've sat through that has tended towards something in that vein.
Yeah, right.
Most of the time it's, this is what we want, this is it. So I think
I
that
agree.
I don't want to object to anything you say, but I think that making a blanket statement that we give them a lot of leeway, we gave Mr. Weiner leeway because he was presenting and he was getting towards something. And yes, those Supreme Court cases, they were interesting, and they were, I think one can argue the merits of where they fell into this in terms of how a right-of-way dedication was taken. And I think his tact was that the hardship was found from the owners on because of this right-of-way dedication, and there was.
I think we should refrain from talking about the case lest we.
Yeah, I think
I
think what you're saying makes sense, and I think I think we should probably move on from it. Since it is going to come back before you guys, I just would say, I mean, we'll certainly keep those comments in mind, but given that this board appeals straight to the circuit court and their only opportunity to make any appeal is to a court versus instead of within the city commission or things like that, we just try to give them as much leeway as we can, and still, but we can cut them off for relevance, certainly. And so, if there are things, if we look back at it and there are things that we want to change moving forward, we'll make those adjustments.
I was just making a comment that none of us cut this individual off in this case.
Are we allowed to?
Probably, and maybe that's okay.
I guess maybe through the chair.
Yeah, I mean, you could maybe make a point of order if you wanted to address something during it, or if you felt like, or if I felt like it was irrelevant, I could have said something. I did say something at some point, if you think that he needs to, move forward, you could make that adjustment. But, again, I think you guys did a great job. I think we're good.
Are there any other staff comments or council comments or board comments? Okay, well, we can adjourn.